Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with having both sides of a deal but not being dual agency. So how could that be? Well, let's first go back to the definition of dual agency. Dual agency is defined as one broker, well, not the definition, but here's what it is. One broker, one agent, and that brokerage has a client relationship with both the seller and the buyer. Is dual agency illegal? No. Is it tricky? Yes. It is not illegal as long as there is written disclosure about dual agency and both clients consent to the dual agency. Now, you do want to make sure that you check with your brokerage to find out the policy's firm on dual agency. Maximum One companies do not allow dual agency. So since dual agency involves a client relationship with both the seller and the buyer, let's backtrack that a little bit. What creates the client relationship? Well, in Georgia, for real property, the client relationship is contractually based. So what contract would a public buyer and a public seller sign to become a client of the broker? Well, it would be the listing agreement and the buyer brokerage agreement. So in the GAR forms, the exclusive listing agreement is F1, and the non-exclusive seller listing agreement is F2. Now, the non-exclusive listing agreement still creates the client relationship between the public seller and the broker. The issue is it creates a client relationship with this broker, this broker, this broker, this broker, and whichever broker brings about a transaction that closes first gets the commission. Now, the listing FMLS will not accept a listing in their listing service signed under a non-exclusive broker relationship. So you know if you find a property in FMLS that the seller had signed an exclusive listing agreement with that broker. So back to the documents that create the client relationship. For the buyer, it's the buyer brokerage agreement. And in the GAR forms, it is F4. Now, in the RE forms, the buyer brokerage agreement is RE 150. The non-exclusive in the RE forms is RE 162. And I'm sorry, RE 150 is the buyer brokerage. The exclusive right to sell is RE 151. Non-exclusive right to sell is RE 152. And those are the forms, and the buyer brokerage is RE 150. So those are the documents that the public buyer and the public seller would sign to create the client relationship between them and the broker, with you as the affiliated licensee of the broker. So how could you have both sides? What's the situation where you would have both sides, but wouldn't it be dual agency? So let's say you have a property listed and you get a sign call. Let's say that buyer wants to buy the property. Well, as long as that buyer doesn't sign a buyer brokerage agreement with your broker, you can still have both sides of the transaction, and it would not be dual agency if they don't become a client of the broker. Again, is it tricky? Yes. Check with your broker to make sure your broker allows it if you're not a Maximum One agent. At Maximum One, we do allow you to have both sides with a lot of discussion with both parties. Now, what are the laws? What's the license law regarding all this? Well, BRETA, which is the Brokerage Relationships and Real Estate Transactions Act, which came about in 1994 and then was amended in 2001, that body of law states that if a public person is going to be represented by the brokerage as a client, they absolutely must sign the agreement that outlines that relationship and the responsibilities of both parties one to another and how that representation works. So that is for the seller being a client and the buyer, especially the buyer brokerage. That's basically where our buyer brokerage laws first came in. There are no license laws regarding a customer signing any documentation to be a customer of the brokerage, to have that broker represent them. That's kind of a bad choice of words, but work with them as a customer relative to this transaction. Now, at Maximum One, our policy is we require that the public does sign the customer agreements. If you're not with Maximum One, check with your broker. Regardless if you're not with Maximum One or not, strongly suggest that you do have your public sign the customer documents so they are under full disclosure and full understanding of their relationship with the brokerage and with you, the agent. So to work with a, well, let's just start with the buyer from that scenario that you have a listing and you get a signed call. In the GAR form, it is GAR F6, Agreement to Work with Buyer as Customer. And when you read through that, the first paragraph, paragraph 1, Agreement to Work with Buyer as Customer. Buyer hereby agrees to work with broker in locating real property to purchase suitable to buyer's needs. In working with buyer, broker shall not be representing buyer as a client, but shall only be working with the buyer as a customer. As a customer, broker cannot represent or advise the buyer on brokerage matters as the broker would be able to do if the broker were representing the buyer, but can only perform ministerial acts on behalf of the buyer. The term client, customer, and ministerial acts shall have the meaning that they have in the Brokerage Relationships in Real Estate Transactions Act, BRETA, that I just mentioned, and that is OCGA 10-6A-1, and then there's more subparagraphs to that. Buyer or broker can terminate this agreement at any time upon written or electronic notice to the other party. And then it does say, though, that the broker is still entitled to commission. And then there's more information on that. In the RE forms, the working with the buyer as a customer, it is RE form 159, Acknowledgement of Customer. And that, again, clearly states that the undersigned, and you fill in the person's name, acknowledges that under Georgia law, the real estate broker is prohibited from representing a party as a client unless they have entered into written agreement with that broker. Again, those are the BRETA laws that we've been discussing. Until such time customer enters into a written brokerage agreement with the broker, broker's role in any Georgia real estate transaction in which the customer is a party shall be limited to providing ministerial services to the customer. It shall be the customer's sole responsibility to protect the customer's interests. Customer acknowledges that customer has not relied on or been offered any real estate advice by the broker, and that any brochures provided by the broker to the customer containing general real estate advice has been provided as a courtesy only and shall not be deemed to create a client relationship. So that's when you're working with the public as a public buyer as a customer. And it doesn't have to be just in a signed call situation. It could be just there's a public person, they don't want to work with you as a client. Now, the paperwork that outlines the customer relationship with the seller is the authorization to show unlisted property, and the GAR form is F3, authorization to show unlisted property. And again, that goes on and it has a lot of information, and specifically it does state in paragraph 11 of that document, no brokerage relationship between seller and broker. This agreement shall not be construed to create a brokerage agreement between the owner and the broker, but rather is limited to the owner's permission to give broker to show the above property to prospective buyers and or tenants pursuant to the above authorization. And the authorization is all the other information you fill out in that form. In exchange for compensation, a broker set forth above. The parties understanding that the broker is a customer and that as such, broker may perform, here we go, ministerial acts to the owner. It is understood that this agreement in no way prohibits the owner from selling or leasing the property directly to a buyer or tenant other than the prospective buyers or tenants listed above and subsequently provided to by the broker to the owner. Owner shall retain the right to enter into a listing agreement concerning the property with any other real estate broker. And again, it has other disclosures and you get a signature and it talks about commission. That form in the RE forms contract package is RE 158, seller authorization to show property without a listing. And again, it talks about the same thing in paragraph 3. Seller acknowledges that under Georgia law, a licensed real estate broker is prohibited from representing a party as a client unless the client has entered into written agreement with that broker to be represented as a client. Again, Beretta. And again, it just talks about ministerial acts. So you want to take a look at those if you want to work, if the parties want to work with you as a customer. So we already talked about the sign call type situation. There could be other situations too. Let's say you have a past client or somebody that comes to you, and let's say they have a tenant in the house and the tenant ends up deciding that they want to actually purchase the home. So one of the parties contacts you and wants you to do the deal, write up the paperwork, take it to close, help them with a closing attorney, so forth and so on, but they don't want to be represented as a client. So you could work with both parties as customers or one or the other as a customer. Nami, do you want to be a customer or a client? So there are a variety of situations where a party would not necessarily want to be a client of the brokerage, but still wants you to help them with the transaction, with the paperwork, performing ministerial acts to get it done. So what do you do as an agent? What do you sign? Well, on the purchase and sale agreement, where it talks about agency, whether you are on the GAR purchase and sale or the RE forms purchase and sale, they both have a place to discuss the agency relationship between the public and your broker. So you're going to have your broker name. So you're going to have Maximum One Realty, maximum under the buyer side, and Maximum One Realty under the seller side. And then under that, the nature of the relationship, you're going to check which box applies if you're working with them as a client or a customer. So let's go back, for example, to the situation where you have a listing and it's in MLS. So you have an exclusive listing agreement signed with the seller. So you've got a client relationship with the seller and you get a sign call. You sign the customer acknowledgement with the buyer. So you're working with the seller as a client and the buyer as a customer. So on the purchase and sale, under the agency part, it's going to have the same brokerage name under the brokerage, and under the seller, it's going to say client, and under the buyer, it's going to say customer. Then on the signature page, you're going to sign as the agent both sides. You're going to sign the seller side with your brokerage name, your contact information, because your brokerage, Maximum One, is working with the seller, and Maximum One is also working with the buyer. So you're also going to sign the buyer side of the signature page. So at the bottom, you're still going to put your company, your name, your license number, firm number, so forth and so on. The only difference is whichever party you are representing as a customer, on the signature page, you must also include one of 3 pieces of information. Either that customer's physical address for mailing, I guess that'd be mailing address, their email address, or their fax number. Now, you must include one of those 3 pieces of information for notice purposes. Whole nother set of videos. The party whom you are representing as a client, you don't need that information. You only need your information for purposes of notice. So I hope this contract tip helped you out. There seems to have been a little bit of confusion, not necessarily understanding the client-customer relationships, but actually how to sign the purchase and sale agreement. If you are working with the GAR contracts, there is a consumer brochure, and that is Consumer Brochure B9, the ABCs of Agency. So if you are working with a party, whether it be a buyer or a seller, and they want some more information when you have this discussion with them about the differences between working with the broker as a client or a customer, this is a fabulous brochure from GAR. Again, it's called the ABCs of Agency, that helps explain a little bit about the differences and what you as an agent can do with them regarding the information with the transaction and the responsibilities performing ministerial acts. Now, we also know from license law, everybody has a duty to be open, honest, forthright, courteous, of course. That's not in license law, but that is in the Code of Ethics. With any party with whom you are working, whether you are working with that party as a customer or a client. So thank you so much for watching. Hope this contract tip helped you out. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.